we have no problem with the week's adjournment. And my client intends to go make his drug test right after he leaves here. So.
All right. So what I'll do is adjourn this to next Friday. That's May 10th at 8:15 a.m.
Thank you, Your Honor.
All right. Thank you.
I'll go back on.
Thank you, Your Honor.
Ms. Heskey. Mr. Hartung, Mr. Daly, are you ready to proceed with Mr. Carden?
Yes, Your Honor.
All right, we are on the record in file 21-20304-FC, People versus Christopher Lee Ryan Carden. We are here today for sentencing in this case, and we are proceeding today by video conference and also in person. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Good morning. Doug Hartung appearing today for the people.
James Darren on behalf of the defendant.
And sir, you are Christopher Lee Ryan Carden?
Yes, sir.
Mr. Carden, this is a sentencing in a felony case. As a result of that, you have a right to be present in person in the courtroom for your sentencing hearing. I would only proceed by a video conference if you're willing to waive that right and continue by Zoom as we're doing now. Are you willing to do that?
No, sir.
All right. We will contact the jail and ask to have you brought over.
All right, thank you.
All right, here. Thank you. Why don't we credit the card? Okay. The
Judge Osagers. The judge says that the camera is off and the microphone is muted. Where Mr. Madrid is supposed to be? Okay. Whatever jails do they have?
It's jail Zoom.
Okay, he says it's jail Zoom 1. Was it the one that Carden was in? Yes, he says yes, it was. Okay. Thank you. Bye. Thank you. Enjoy your night.
Okay, Ms. Edward, you need to speak to Mr. Murray.
Thanks, Mr. Lee.
Yep.
Okay, we're on the record in file 23-21441-FH, People versus Alejandro Luis Madrid. We're here today for sentencing on a probation violation, and we are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Ron Underwood for Mr. Madrid this morning, Your Honor. Thank you.
And sir, you are Alejandro Luis Madrid?
Yes, sir.
All right, Mr. Madrid, this is a sentencing in a felony case. As a result of that, you have a right to be present in person here in the courtroom for this sentencing hearing. I would only continue today by video conference if you're willing to waive that right and continue by Zoom as we're doing now. Are you willing to do that?
Yes, sir.
Okay, have you had an opportunity to read and review your pre-sentence report?
Yes, me and Miss Underwood just went over it.
Okay, and you've had an opportunity to discuss it with her then?
Yeah.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, I am.
You wish to explain or challenge the accuracy or relevancy of any of the information that's in your pre-sentence report?
No.
Before the court passes sentence, Ms. Underwood, is there anything you'd like to say on behalf of Mr. Madrid?
Thank you, Your Honor. Mr. Madrid, I think, is finally acknowledging and getting real about the substance abuse problem he has, Your Honor. I think the recommendation in this matter of immediate treatment is very appropriate, and so does Mr. Madrid. And we welcome Mr. Moore's recommendation, and Mr. Madrid looks forward to that supervision, Your Honor.
All right, Mr. Madrid, is there anything you'd like to say on your own behalf?
No, sir.
All right. I have reviewed the updated pre-sentence report along with its recommendation. I am going to follow it. I will say, though, Mr. Madrid, that you have now had one opportunity at receiving treatment. I'm going to give you a second opportunity at receiving treatment. And at some point, and your attorney, Ms. Underwood, said you're ready to be serious about it, but at some point, you really have to make the decision to be serious and to engage in your treatment and to do the treatment. Because if the more times that someone comes back before me and says, well, I didn't do it this time, but I will do it next time, it gets harder to believe each time, either that you're serious about it or that you're capable of being serious about it. And that's kind of the situation that you find yourself in right now. We're offering you help again, but you need to make the decision to take advantage of that help. Because if we continue to go forward with the behavior that we've seen on probation so far, at some point I have to say that incarceration is better for society than to have you out continuing to engage in the same behaviors that got you here in the first place. So I hope you'll take advantage of it. You seem the last couple times you've been here and been present in court, you seem a little bit different, like maybe it has hit home this time, and I really hope it has. I hope you'll take advantage of this opportunity. So it will be a sentence of the court that you be reinstated to probation without credit for time served of 51 days. And you must immediately commence treatment promptly upon release from jail. When you do get released from jail, you need to come directly over to the courthouse and check in with the probation department.
Yes, sir.
And find out from them, what your next steps are going to be.
Okay. Thank you.
You do have the ability to request an appeal of your sentence. We'll send over to you 3 copies of a notice of right to appellate review and request for appointment of attorney form. When you get those, you need to sign one of them and return it to us. That just means you got your copies of those forms. If you wanted to request an appeal of your sentence, you would need to fill out the other copies of those forms and mail those to the address listed in those forms within 42 days. All right, so you are all set. You can let the officer with you know that you're done with Fort.
All right, thanks. Have a good day.
Thank you.
Could we have Ryan?
Mr. Hartman.
Let me do this over here. Bench warrant? Yeah. Is it okay if I go next door and do a quick bench warrant?
Judge James wants somebody to come to you.
I think Mr. Carden's coming in. Well, yeah,
That's fine. That's fine.
now because Mr. Carden's going to take over, so, and she's got a trial. So
Me go.
yeah, yeah.
Thank you, Judge.
All right, Ms. Underwood, you need to speak to Mr. Collar.
Yes, please, Your Honor.
Okay, we are on the record in file 23-21350-FH People versus Brian Cody Collar. We are here today for sentencing in this case, and we are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Collar, Your Honor.
And this is, Mr. Collar had only pled to a felony. So Mr., I'm sorry, sir, you are Brian Cody Collar. Your device is muted, Mr. Collar. I'm going to send you a request to unmute that device.
I thought I pled to a misdemeanor.
Yeah, I misspoke. I apologize.
Yeah, you're right. Thank you, sir.
Okay, and you are Brian Cody Collar?
Yes, sir.
Okay, and as I said, I did misspeak. Mr. Collar pled to a misdemeanor in this case, not a felony. And so, Mr. Collar, did you receive a copy of the recommendation from Mr. McCarron?
No, I did not, sir.
All right, Ms.
Your Honor, can I be heard for just a second?
Go ahead.
Your Honor, Mr. Collar has new charges in district court. And I would respectfully ask to postpone this a week so we can kind of get a handle on what Mr. Collar wants to do based on that.
Okay. Give me just 1 second to look at our schedule for next week and see how many sentences we have. All right, so I'll set for May 10th at 8:15.
Thank you, Your Honor.
Thank you, sir.
Okay. Thank you.
I'm all set.
You're all set. Thanks.
I believe that concludes my docket with you today, Your Honor. Have a good weekend.
Okay, thank you. You too, Ms. Underwood. All right, are we ready to bring in Mr. Carden?
Yes, sir. Yes, sir.
All right, we are back on the record in file 21-20304-FC, People versus Christopher Lee Ryan Carden. We are now proceeding in person. So at this point, Mr. Carden, you had an opportunity to read and review your pre-sentence report.
Yes, sir, I have.
You had an opportunity to discuss that report with Mr. Daly.
No, sir. I'm not, like, I wasn't aware that my sentencing was going to be today. My sentencing date has been adjourned for the last year and a half. And as you can see, I don't have no family support out here. No, I wasn't prepared to be sentenced today. This was thrown at me this morning, and I wasn't even made aware. Mr. Daly haven't come talk to me all week because he said he wasn't aware that I was getting sentenced today. I haven't even gotten the court paperwork in 6 months. I had no clue that I had a court date today, and like I just asked if I could get even to this afternoon so I could get my family around so that they could be here for support for me. I was under the impression I wasn't getting sentenced until August, July.
All right, at this point, the court does have a stipulation in order in the court records adjourning the sentencing hearing to today. That was agreed to by both prosecution and defense. And it would be my than to proceed with. It has been appropriately noticed.
You have my signature on that document.
Does not require your signature, sir.
I've been made aware of that document. You're trying to tell me.
You're represented by an attorney and your attorney signed the document. So that is what is required in terms of adjournment sentencing.
Well, then I need ineffective assistance in counsel because I was not made aware of this court date, sir. I've been adjourning my court date for the last year and a half. And then now it gets sprung on me this morning. My family, as you can see in here, you think my family wouldn't be here if they knew I was getting sentenced today. And I have a high profile case, they would be here. My family, I have family support and they're not here. And so I was not made aware of this court date. When my last thing that I even had, and Doug Hartung can attest to this too, the prosecution, my thing was that he said for me till August. I haven't seen Mr. Daly, sir. And I'm not trying to be rude or anything, but I mean, you're about to take my whole life from me. And I deserve a chance to have family support. And I was not made aware of this court date. I did not know nothing about this court date. They probably thought they didn't even have it adjusted in their system at the jail for this court date. The jail didn't even know about this court date.
Sir, your objection to proceeding today is on the record. If you would like more time to discuss the pre-sentence report or any other issues with Mr. Daly, I'll give you that. But I am going to proceed today.
Like this afternoon?
I'm proceeding right now.
He can have 20 minutes to talk to Mr. Daly. If he needs to.
Your Honor, Mr. Carden and I already talked several times about this, but everything that Mr. Carden says here today is basically correct. He didn't think the sentencing was going to go today. I did not believe the sentencing was going to go today. He still has individuals that he is going to testify against. Originally, his sentence was going to, at least the recommendation from the prosecutor's office, in large part were going to be determined about his cooperation in other cases. And in several cases so far, Mr. Carden has provided information and testimony to the prosecutor's office on several cases. I think he's been an asset to them in that. And I know the prosecutor's office always keeps their word, and they've indicated that they were going to reflect this in a sentencing. The problem is, I don't think the prosecutor really had much more notice about this than I did, as far as the fact that there's been problems at the jail, and now they're hurrying the sentencing up. What I think the prosecutor or the state wants to do in this case now is sentence Mr. Carden, and with a understanding that when he finishes his testimony, he can come back to court and ask to have a resentencing. Relates to the facts, the allegations, everything. Mr. Carden and I have been over this many, many times in the past. But so right now, I understand there's issues at the jail that's going to require a sentencing. I understand that. And if the prosecutor's going to leave room for Mr. Carden to come back and be resentenced after he has finished his testimony in his other cases, I guess the only difference that would really mean is that he would be incarcerated at DOC rather than at the jail until those times occur. But he doesn't have his family here. He doesn't have anybody here. We haven't been able to have those kinds of conversations because I didn't believe it was going to go today. I think this is Well, I don't know, there's been several adjournments on it. It's nobody's fault other than the fact that we're trying to get this resolved, and we still are. But that's where my position is at right now. We are here. I can proceed to sentencing if the court requires, and I think the court's going to require that. But I just wanted to put those things on the basis before we proceeded any further.
Much of what he said is accurate. It is true that Ms. Weiss and myself have gone to bat for him with the sheriff and with the jail command. And we did so numerous times because Mr. Carden continuously cannot stop getting in trouble at our jail. And it is also true that we would love to have an opportunity to have him present to the court all of the things he has done, so the court would have a full picture of what he's put into this. But at our last meeting here in this court, the last time we adjourned this, it was very clear that he was out of chances. I myself spoke to Mr. Carden on the second floor of this building and told him that you are out of chances. And something happened at the jail relatively recently, and that was it. We had to tell the sheriff that we have to go forward and get Mr. Carden sentenced, whether it be today, this afternoon, or another day, but we have to get it done because he has violated the agreement that we made with him at that point in time. I continuously and firmly will tell the court everything he has done. I will always do that. I will always honor Mr. Carden in that respect and make sure that this court is aware of what he's done. It will take away some of the penalty, perhaps, of the very heinous crimes that he has committed here, but it certainly won't take all of them away. The court has every right to sentence him today. Mr. Carden was aware that if something happened at the jail one next time, we would have to go forward and sentence him. We were advised that something happened. We received police reports to that effect. Something did happen. He violated the agreement. Therefore, it is appropriate to sentence him today for another time that this court adjourns.
Though with the respect, after that conversation, I haven't had no incidents. I'm still in orange. I haven't saw nobody. I haven't did anything. I've had no incidents since me and Ms. Wise and you had that conversation. I have no incidents.
We were, just so the court's on the record, we were apprised otherwise it wasn't an assaultive incident, but it was an incident involving conspiracy and drugs and things of that nature.
I had nothing to do with it.
I'm gonna take a few minutes recess.
He wants to check something. He wants to check something. He'll be back. My understanding is it's or well, over else is over there needs to be sentenced.
I just gave her a lifetime.
That's what I wanted her to get close. Forget it, but just push it, push it. I would.
So there is she's not so yeah. Way to go.
Right now, we were talking about.
Yeah. I just brought some.
You can do it. You can do it. You could ask for 43 more, actually.
Going back to what's the best interest of the child.
That.
Are you still downstairs? Okay, did Michael Jackson show up? I don't know when that's going to be. What do you got going on? If you get a chance, I got locked out of my iPad. I don't know why. You guys, yeah, if you could.
But she doesn't help us. She'll be like, well, just ask. Yeah. How I ended up at every, you know, all the way through it out. She's like, she basically says that everything next will take the one. Stands up, stands up. Yeah, that's what I'm not really, no, so.
Did you get locked out?
I can't find her.
Oh. You know why? It's probably because, it's probably because it's past the time. Okay. Did it get to leave it?
She was really young. She wasn't that old. Say, I'll just call. See, actually. Yeah.
No, not here. So yeah, she was. I think it was gonna be a sense. Okay. I really am. This.
Or let me see. You.
All right. Recorded. Maybe see. Right, we are back on the record in file 21-0304-FC. I have had an opportunity to consider situation and consider what's been said on the record here this morning. Based on what I have heard from Mr. Carden and is not having had an opportunity to arrange to have some people who may have something to say in support of him. I don't know exactly what the situation is, but what I'm going to do is adjourn this until 3 p.m. I would suggest that the
I won't be available at 3 p.m. Your I'm supposed to be in Jackson. I've got other issues going on. This afternoon will not work. At least very difficult for me to make it work. And I won't be able to work on it, but they're waiting for me downstairs. I won't be able to even get to Carden until this afternoon. Then I've got to call his family, those type of things. And also, Mr. Carden now doesn't believe that he's getting the benefit of his plea bargain.
Yeah, I'd like to withdraw my plea, sir.
What is the basis for the request to withdraw the plea?
I don't feel this,
You're represented by an attorney. Your attorney needs to speak for you.
I'm sorry, sir.
I'm sorry, Your Honor, I didn't hear you.
You need to speak for Mr. Carden. He's represented by an attorney. He's not allowed to
I
address the
understand.
court directly. I want to know what the basis for the request to withdraw the plea is.
Plea is, Your Honor. Mr. Carden pled guilty. After he had pled guilty, and he realized the consequences of his guilty plea and what he was facing, he entered into a series of conversations with law enforcement, prosecutor's office, many of which I wasn't involved in, one of which involved the case of State versus Trevino, among others. And obviously I wasn't involved in anything with that as it relates to Mr. Carden. But Mr. Carden now thinks he's getting the benefit of nothing. He has absolutely nothing to lose, in his opinion, by going to trial. And that's what he would prefer to do at this time.
I understand you correctly, Mr. Daly, to say that these are conversations that occurred after he entered his plea.
I'm sorry, Judge.
Did I understand you correctly to say these are conversations that occurred after this conversation about adjourning the plea and adjourning the sentencing as we've done for over 2 years now?
Yes.
That these conversations occurred after the plea was entered?
Oh, yes.
No.
Do you
Is there
recall?
anything you want to say with respect to that issue?
Yeah, I will. At the time the plea was entered, the court went through all the proper rights that were given. And I don't think anything was placed on the record at that time regarding him cooperating. However, if there was anything placed on the record at that time, it would have been regarding his wife, Jamie Carden.
And Christopher Mauer. Christopher
Possibly,
Mauer,
possibly
when I took my plea, it was.
Hold on, Chris. And possibly Christopher Mauer. And you will be advised of what he's done in those cases. Subsequent to that, there were conversations that occurred regarding other cases, but those would have been the only two that would have been brought up at the time of this plea. Even if they were put on the record, which I'm not sure they were, but we will acknowledge that those two were discussed in advance of the plea. We will obviously make sure the court is aware and assist in those cases, as well as other cases that he's assisted in, Your Honor. What's that?
Yeah, just give me some. Okay.
What do you want to do?
Yeah, she showed up. That's my
How does she- It's not right.
Okay, how's it going with you? Yeah. No, one case. Oh.
Really?
I would just ask. Is anybody else?
I had no idea the sense of these girls. Yeah. I had a couple of Jacksons. I drew by that sheet, so focused on that. Yeah.
I don't do.
Yeah.
But people that are not exhausted, clients, we don't have to be here today.
You guys gotta take care of it. I had it from the jails, pushing me out.
They were pushing for a long while. That's why I read it. So.
And he says he didn't do anything about it.
Video. He's not much of a liar, isn't he? But I mean, anyway.
What the judges do it now. You give us some Monday. You know what? I've been tired. The cost. No, the church. How can you be here? I've been tired of that shit. I'm always here. Yeah.
What do you got next stage?
Thanks. I think it's kind of two cases and both I got to be true to stay on the list. Charging just everything's not new truth.
Very often, no.
Yeah, because yeah. Certification. We did it. February. That in here.
That's right.
Oh, I'm doing. Yeah. So. He's right here in front.
I'm Kelly's in here.
Apparently at this time. I get it. Yeah, I guess.
Okay. Hey, if they can ask, if they can check with the judge.
Okay.
I'll look at what's. He's out of court.
That whole crime. Yeah. last year.
Hey, we need down here, you get some interest real quick.
The problem is I haven't been released by this judge. I'm happy to go, but if they can get somebody to clear me, the judge is not in the room. He has to release me. Okay.
One of the two places at the same time. We need you here, but wait, no.
Yeah, I saw that. Yeah. No, it is very strong.
All rise. Circuit Court in session. May we see. Right, we are back on the record in file 21-20304-FC, People versus Christopher Lee Ryan Carden. I have had a chance to consider this further, and at this point, I do not believe that I can continue today without a significant risk of there being a reversible error. Having said that, I will adjourn this hearing to 1 week from today, Friday, May 10th at 8:15 a.m. At that point, I will rule on the request to withdraw the plea. In the event that that were to be denied, I would proceed with the sentencing at that time. So with that we are absolutely clear. There is a potential that the sentencing hearing will continue on May 10th at 8:15. And so everyone needs to be prepared for that. Court will not entertain any further requests for adjournment, whether those be agreed to by the parties or not.
Thank you, Your Honor.
I think we will. Good luck, Mr. Reeves.
Take care, Chad. Good luck with that one.
Thanks.
Go to the office afterward.
Yeah, I meant to come by, but Katerina was, I didn't notice that she had joined, I got tired of the beach or something. Yeah, I still need to relax. Oh, are you? Yeah, very nice. Are you starting to do that at all the first Fridays?
I think so.
Oh, all right, I like the new tradition.
Okay.
All right, Sheriff. The other
She, well, she
Are
was
they gonna
here.
or-
Yeah,
She was.
blonde hair.
What's her name?
Lady.
Brittany.
Brittany. Brittany, yes. Brittany.
Rise. Circuit Court in session. Maybe seated.